to video 3114 from the Legal Studies guy. Today we're going to be talking about factors considered in sentencing. So we've just gone through in the past two videos the purposes of sentencing, some common types of sentences or sanctions that are handed down to offenders, and now we're going to look at effectively the things the judge is going to take into account when making those decisions. Quote today, a Gandhi one, an eye for an eye only ends up making the whole world blind. Just that idea of, if you spend your whole life, I guess, seeking retribution or revenge or trying to, keep score and keep everything even, you're just going to, cause more harm than good. So a little bit around the idea of forgiveness and just trying to move on from things, which can help you live a much more calmer and fulfilling life. As I said today, we are looking at 3114, so the factors considered in sentencing. And effectively at the end of this, I just want you to understand what's a judge considering when they're handing out a sentence to an offender. What sort of things are they taking into account when they make that decision? There are 4 listed in the study design. These are the 4 that we need to know. And effectively, we're looking at this idea that when the judge is deciding what sanction and then how long or the conditions attached to that sanction that they're going to give you, they're going to take into account as many circumstances as they can. So they're going to look at factors about you as an offender, the circumstances of the offender, the impact of the action, to try and come up with the most appropriate consequence to fit your circumstances. This is a really, really good one with sentencing in general. It's really, really good to think about things like the school setting that you're in right now. And, again, generally not as many behavioural issues in classrooms when you're in sort of year 11 and 12. But if you think back to year 7 and 8, and think about some of the common behavioural things that occur in class, whether it's talking over the teacher, yelling out, moving out of your seat, etc. And you start thinking about, okay, what sort of consequences did a teacher give me? It might be simple things like seating plans or moving you away from your friends, because that's trying to truly address the cause of that offending. But also, as certain consequences are given and don't perhaps work, so we're starting to think about repeat offending here, or people who continue to do the wrong thing despite reminders or consequences that thing is wrong, we might start getting consequences that become more severe. So we start talking about the fact that your culpability is increased the more you do the wrong thing, because the consequences given to you should show you that is the wrong thing. So we start thinking about things that aggravate your culpability, and subsequently, as a function of that, will aggravate or increase the type of sanction or sentence you're given. So again, that classroom setting, that might be moved outside, sent to a year level office, or sent to your coordinators, or ultimately, as the offending gets worse or the behaviour gets worse at school, you get more serious consequences. There obviously are things that mitigate your culpability, so reduce the level of blame you have as well. And these are things that we're talking about at the start, like that more simple first-time offender, the younger you are, things that make you less responsible for your behaviour. Whether you own up to it is really important, so guilty pleas, and we'll talk about those. And then obviously the impact of the actions is really important, so hearing from a victim is really important as part of this process. So aggravating factors. As I said, aggravating factors are things that increase your level of culpability. So increase your level of culpability. And this is really important. Culpability is the concept of how responsible you are for your behaviour. So how much ownership you have for what you did. And culpability is really, really important in then determining the sanction that you should get. effectively, if you are more responsible for your behaviour, you deserve a more serious sanction than if you have factors that might lower your level of responsibility, such as mitigating factors. By having an increased level of culpability, you will naturally then get to an increased sanction or sentence. But it's important that you describe aggravating factors as increasing your culpability, or mitigating, which we'll get to in a moment, as decreasing your culpability. Because if you describe it as an aggravating factor increasing your sentence, that's a bit of what we would call an inaccuracy, where you're not quite truly understanding the sentencing process, which I'll talk through in a moment. Aggravating factors, things that make you more responsible for your behaviour, can include things like premeditating, so putting a degree of planning into what ultimately is the offence you commit. That is definitely something that makes you more culpable than if it was more of a spur of the moment behaviour. Using a weapon, breaching trust, which is the picture we got here, that famous meme. This guy's with his partner over here and checking out another woman. It's the idea that he's breaching trust. It makes your behaviour that little bit worse. It makes you a little bit more responsible for it. This is in opposition to mitigating factors. So these are those that decrease your culpability or the level of responsibility. And these include things like I went over in that first slide: your personal circumstances, your age, your background. They might take into account your cognitive ability, whether you've demonstrated remorse, do you cooperate with authorities, are you already showing an understanding that what you did was wrong, lack of prior offending, whereas with aggravating factors it might be prior offending that increase your culpability, and ultimately more of these will effectively, or a greater, or stronger mitigating factors will ultimately lead to a decreased sentence once the whole thing is considered by the judge. Now, why it's important to talk about increased culpability and decreased culpability is to truly show that you understand the sentencing process. If you say an aggravating factor increases a sentence, or a mitigating factor decreases a sentence, you are giving off the implication that when a judge sentences someone, that they start with, say, I'm going to send this person to prison for 2 years, and then they look at some aggravating factors and go, oh, aggravating factor, I'm going to lift it to 2 years, 6 months. Oh, another aggravating factor, I'm going to go to 3 years. Oh, there's a mitigating factor, I'm going to bring it down to 2 years, 9 months. That's not how sentencing works. It's not a plus and minus exercise where a judge starts at a point and adds and takes away. Sentencing is much more all of this stuff, these mitigating factors, aggravating factors, guilty pleas, victim impact that we'll get to. All of this gets thrown into a pot, in a way, cooked up in a big stew, and the judge considers all of these things in totality. The judge considers all these things as a group, as a whole concoction, and then ultimately decides on the most appropriate outcome based on that. And that's really where sentencing comes down to the expertise of the judge. And it is the responsibility of the judge alone. There are elements of precedent that are used in sentencing in submissions. There's reference to, hey, this person with similar circumstances got this, but ultimately every sentence is tailored to the individual in front of the judge based on all of these things being considered in their totality. So that's why it's very, very important that you describe aggravating factors and mitigating factors as increasing culpability or decreasing culpability, not sentence. The Sentencing Council, the Sentencing Advisory Council, actually did a bit of a survey. So this is aggravating factors and mitigating factors. So this is just a bit of a list of them. But they actually asked, juries aren't involved in sentencing, but they actually asked jurors who'd been involved in cases and then judges involved in cases how much weight they gave to these factors, just so you can consider how important, different aggravating factors are versus different mitigating factors. And you'll find here that, so judges are the blue one. Judges, when they're sentencing someone, they find, say, if there's a breach of trust involved, so think, known to the victim, perhaps, family violence related types of offences, they found if there's a breach of trust involved that they gave a lot of weight, like 92% of judges gave a lot of weight to that as an aggravating factor. That's something that really increases a person's culpability. If the victim is vulnerable, really increases a person's culpability. The level of injury to the victim, so that's showing how important victim impact statements are, which we'll talk about in a moment. And then you get down to like prior convictions. A jury, like the general public, gives that a little bit more weight than judges do. Just over half of judges gave that significant weight in their sentencing process. And that could come down to a lot of factors around whether, the prior convictions were connected in any way to the current offending, etc. And breach of bail, parole, or sentence, a bit lower. It's really interesting that if we then look at mitigating factors and how much weight those are given, all of these are significantly lower, which indicates that judges and the community much more likely to look at the bad things, the things that increase culpability, and give that significant weight than they actually are to look at things that reduce your level of ownership or responsibility. And you'll see really common things here that are considered by judges in sentencing with significant weight. The age of the offender, so their youth, which then sort of sticks into prospects of rehabilitation, important things for judges to consider, and were you a first-time offender. So those things sort of all link together around that idea of a judge will give quite a lot of weight, and I mean, it's well below 50% for some of them, but the judge will give more weight as a mitigating factor to the idea of, are you going to learn from this? Are you someone who is going to be potentially rehabilitated and able to go back into the community? They don't give as much weight to things like your background, whether it's disadvantaged background, whether the sentence will give hardship to your family, whether you had some kind of illness or impairment that could have caused the issue. So much more weight to those factors of youth, first-time offender, rehabilitation, etc. Guilty pleas is another factor judges will consider in sentencing. Guilty plea will generally, and I say can lead because there are, and I'll show you an example later where it didn't, but guilty pleas will generally lead to a reduced sentence. So there's sort of like two reductions in sentence, or two benefits to pleading guilty that can lead to a reduced sanction. So there is this idea that by pleading guilty, you are indicating ownership and showing remorse. And in a way that can then lead to being an aggravating factor. So the indication of remorse, a mitigating factor. The indication of remorse, ownership of your behaviour, understanding that the behaviour is wrong, I'm going to plead guilty. That also acts as a mitigating factor, which lowers your culpability and then can lead to a reduced sentence. But we also give a baked-in sentence reduction based on the fact it saves the court time and money. You don't have to run a trial. You don't have to cause harm to the victim or potential harm to the victim through them having to be a witness. And as a result, it is included in the Sentencing Act that this should lead to a reduced sanction, or if the sanction stays the same, like imprisonment, a reduction in the time or the sentence. Statistics from the Sentencing Advisory Council show that this reduction is usually between 20 and 30%, and they know this because the Sentencing Act has a section that says if someone pleads guilty, the judge has to include in their sentencing report what sanction they would have given if the person pled not guilty. So they have to include, hey, if you went to trial and were found guilty, this is what I would have given you, but this is what I've given you with your guilty plea. And that enables the Sentencing Advisory Council to look at all of those and estimate what that reduction is. And it's usually between 20 and 30%. So saying, if you were going to be sent to prison for 10 years, but you pled guilty, it's more likely to be 7.5 to 8. 5 years, it's more likely to be down to 4 years, maybe 3.5. So a guilty plea has a really big impact, both as a mitigating factor, potentially, not always, but definitely as a reduction based on the fact you're saving the court time and money. The other thing we'll consider is victim impact statements. Victims are involved in the sentencing process. They get to prepare an official statement, which they can read out as part of the sentencing process at a plea hearing. And they get to talk about how the crime has impacted their life. It may talk about ongoing harm that's happened as a result. It might mention that there was a breach. Excuse my writing, I don't have my pen today. It might mention that there's a breach of trust, which we know is a big aggravating factor. And it might mention the specifics of the injury and loss. So the victim impact statement might actually then contribute to the aggravating factors as well, by allowing the judge to truly see the harm that the victim has suffered. Very rare, but a victim impact statement could also contribute as a mitigating factor, particularly if the victim indicates forgiveness. Actually looked at a sentencing report recently that was a dangerous driving causing death, motor vehicle accident. Driver veered onto the other side of the road, wasn't alcohol or drug affected, killed the oncoming driver. And they were an elderly person, and that person's partner wrote a victim impact statement where they were basically like, I don't want this person to go to jail because they have a family. Yes, I am sad, and yes, what they've taken from me is horrible. But ultimately, I don't want to ruin their life as well. So victim impact statements in very limited circumstances can go the other way and actually, in a way, support a reduced sanction or sentence. But realistically, they will generally act to potentially increase the culpability of the offender and therefore lead to an increased sanction. No clear skill listed in the study design for what we're meant to do with aggravating, mitigating guilty pleas and victim impact statements. But the assumption is just effectively that this is key stuff or key things that you need to define, like we know is the first dot point in every area of study, but also the synthesis skills. So this 3.1.11, this is very much the sort of content that you're applying to a case study. So you might get an example like this. Antoinette is sentenced to a community corrections order for assault. Explain why she may not have been imprisoned and discuss the ability of a CCO to meet the purposes of sanctions. So you might talk about the fact that maybe she hasn't been imprisoned because she's pled guilty, and we know that guilty pleas would lead to a reduced sentence. Maybe this is a sort of skill that in section B, you get a case study. It talks about, you can look back at an old exam about Bob who robbed a service station. It has some details about Bob, or it has some details about the offender, and then you're asked to pick out or explain some aggravating or mitigating factors based on that. So very much a synthesis application skill. I've included a little bit of a discussion on CCOs and whether they meet their purposes there, which might be worth a read as well. But very much for this skill, we're looking for that application of your knowledge to case study scenarios. To finish off, I'll link this here. This is a link to the sentencing remarks made during Martin Bryant's case. Just make some really interesting comments on guilty pleas. Basically, Martin Bryant pled guilty, and the judge said, you're only pleading guilty because you more or less, it's irrefutable what you did. I am giving you no discount for your guilty plea because of the gravity of your offending. So that one's definitely worth a little look. Ultimately, I'm hoping that someone could come and ask you, hey, I'm struggling to understand why this person got this sentence. I read this in the newspaper. And you'll be able to very clearly say, hey, this is why. These are all the factors that the judge would have considered. This is what they would have taken into account. This is how they would have put them into the big pot, cooked them up, looked at it in its totality to figure out what was the best sentence and the best sanction for that individual offender. As always, feedback in the comments below. But end of area 3.1, onto civil law next video.